Okay, and thank you all for your patience while other matters. So, parties for the Daniel Hagan versus Quantum Residential Incorporated. Feel free to make your way on up to the front of the courtroom and we'll get started in 1 moment. I'm just going to go to your case. So I see there was a motion, looks like a motion to allow counsel signed by Judge Johnston.
Yes, Your Honor.
Back. We were currently here on a motions hearing, so if you could talk to me a little bit about why we're here,
Sure.
and I'll hear from the parties. Of course, I'll let all the parties put their
Yes,
names on the record.
absolutely. Thank you, Your Honor. Lindsay Adigbate here on behalf of the plaintiff. So this case started in with a small claims case that was actually not properly served on my client. Sometime in September, they received the claim via fax from some unknown third party. Shortly after that, received the order from Judge Johnston setting this on the motion docket. So in February of 2023 and then in July of 2023, termination notices were issued to Mr. Hagan. And then following the termination notices, a first appearance was set in case 23 LT 12731. The first appearance was held on August 15th, 2023. I will note that while my client did not receive the claim, the small claims notice, they did receive on July 24th, 2023, so approximately 22 days before the first appearance, what appeared to be a demand letter demanding $10,000. So then fast forward to August 15th, 2023, the first appearance took place. My firm appeared and represented Quantum, and a stipulated agreement was entered. It included a vacate date as well as a payment in the amount of $2,900. And it is Quantum's position that the stipulated agreement that was filed in that case that included the monetary amount of $2,900 was a payment to globally resolve all of the landlord-tenant issues. And again, the demand letter was received prior to that time. So it's Quantum's position that that Mr. Hagan is then stopped from pursuing amounts due based on issues related to the tenancy because of the $2,900 payment that was agreed to. And it was also delivered. Mr. Hagan filed a letter with the court. We did not receive a copy from Mr. Hagan, but I noticed it on OECI, a letter, explanation letter, and it included the check. So I don't think there's any dispute that the check was actually received by Mr. Hagan. So that, from Quantum's perspective, that's where we're at today.
Cool. And so essentially, like, there's this landlord-tenant case that, from your perspective, there was an agreement that Mr. Hagan would move out. There was $2,900, and I do have a copy of what looks like the stipulated agreement in order, and that's from August, signed on August 15th by Judge Kirkwood. And I'll hear from you in a moment, Mr. Hagan. I'm just trying to get my footing and kind of see where we all are, so that we're all on the same page about exactly what it is that we're talking about.
And Your Honor, I do have my client here to testify if that's helpful, but...
And we may get to that in a moment.
Sure.
I just wanted to sort of So I'd like to put it in kind of the simplest possible terms. Your feeling and your position is this $2,900 payment to Mr. Hagan took care of everything. That was full stop. Everything's over with at that point.
Yes, Your Honor, that's correct.
Okay. And so you're essentially what we're here for today is you're asking me to you're asking me to agree with that and say that this matter here, this 23 SC 22052 small claims case is stopped. It's not going any further because of that. That's what we're here for.
Yes, correct.
Okay. And so, Mr. Hagan, over to you. Good morning, sir.
Good morning, Ryan.
So it looks like your name is Daniel Hagan. Last name is spelled Hagan.
Correct, yes.
All right. And so again, good morning to you. So you've heard the Quantum Residential's position here. What is your position?
Well, Your Honor,
And keeping in mind, this isn't the full trial. I mean, we're just talking.
Yeah,
about
this is just about the motion.
Did this $2,900 take care of everything or not? So
yeah, exactly, Your Honor. And for me, these are absolutely two unrelated cases that have nothing to do with each other at all. This landlord-tenant is a dismissed case. I complied with all the requirements, and there's nothing in that document that says anything about me not being able to pursue anything going further in the future. There's nothing in there. It just says all I have to do is move out by that date, and I'll receive $2,900. Nor would I have agreed to anything that said that I couldn't in the future. So, I'm just not sure where the word global or, where anything in there would even imply that I could not ever go forward with that. And so for me to address any of the other parts of this, the eviction case, the violations, notices, all that's to me irrelevant. This is a small claims about the habitability of living in the place.
And Ms.
Adigbate, yes.
Adigbate. All right. So turning our attention to this other document, and I guess this was provided by you all, correct, for today, or did we just pull it? Okay. Well, we're going to call it just so for purposes of clarity. I suppose it's all put together. We're all on the same page about.
Is it the stipulated agreement that you're looking at?
Yes, the stipulated agreement. It looks like it was signed by Ms. O'Day, as well as presumably Mr. Hagan. It looks like Mr. O'Day's signature was on it from either the 15th or the 19th. It's kind of hard. I'm assuming it's the 15th, just because presumably everybody was in the same place when this document was signed. It looks like it's signed by Judge Kirkwood as well as by Mr. Hagan on August 15th. So Ms. Adigbate, over to you. You have this document in front of you as well.
I do.
Receiving it in evidence, I guess, is court's exhibit number 1. Is there anything on the agreement that you're able to see that says this agreement is intended to resolve all other matters, and to take care of everything?
No, Your Honor, but I would point to two things to consider in that regard. First is what I alluded to is the timeline. So July 24th, 2023, the demand letter for $10,000 was provided to my client. So just before this agreement was entered. And secondly, in a FED case or an eviction case, there was no requirement that Mr. Hagan settle this. He could have brought counterclaims. He could have provided an answer with counterclaims that would be permissible under ORS 90 and 105. And those issues could have been resolved in this case because it was the case regarding the tenancy and the termination of the tenancy. And so it's our position that there, even absent language that specifically says that this 2,900 is to resolve all of the issues regarding the tenancy. Mr. Hagan had the opportunity to bring those in this case, and he failed to do so, and then was paid an amount of money from our perspective to resolve the tenancy, and is now coming back in a different avenue to request additional funds.
But, and I guess what I'm stuck on here is, I mean, I see obviously it's clear that this is, and I guess sort of going back to sort of contracts 101, I'm seeing this thing is called a stipulated agreement in order. Be fair to say this is a contract, right?
Yes.
And I see, there's all this sort of boilerplate language, there's some blanks that are filled in, and then down at the bottom, it talks about additional terms. Are you able to tell, I know it sounds like Ms. O'Day was probably the one that was there for this hearing. Do you happen to recognize her handwriting, or do you know who
Oh,
written
yes,
this
absolutely. Kylie O'D is an attorney that is in my office, a colleague of mine, and regularly does the first appearance docket here. And I have spoken to her, and she did sign this agreement, and I don't, I believe that any testimony about it would be better suited to come from my client, because my client was the one that directed Miss O'D with the terms of the settlement. And so my client can testify as to what the intent was. I would just bring up for the court that if the court is not convinced that this stopped the tenant, that I'm prepared to present argument about the certificate of service and the fact that if the court is convinced that this case should proceed in the small claims, that it should be dismissed based on lack of proper service.
All right. So, well, I guess we'll hear from any witnesses that you'd like to call, and then of course I'll be happy to hear any arguments.
Sure, absolutely. So I would call Miss Stephanie Workman.
So why not? And good morning, Ms. Burke.
Good morning.
Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're going to provide in this matter today will be the truth, the whole truth?
Yes.
Your witness.
Thank you. Miss Workman, who is your employer?
Quantum Residential.
And what is your title?
I'm a regional portfolio manager.
And
Yeah.
sorry, I didn't mean to, but before you go any further, could you please state your full name, spell your last name for the record, just so that it's...
Yes. It's Stephanie Workman. It's S-T-E, F as in Frank, F as in Frank, N as in Nancy, E-Y, and W-O-R-K-M-A-N.
Okay, sorry, go ahead.
No problem. And as your role as the regional portfolio manager, is part of your duties to oversee the general operations of several properties?
Yes.
And does that include Argyle Gardens? Okay. And do you know Mr. Hagan?
I don't know him personally, but I'm aware of his tenancy, yes.
Okay. And have you received any communication from him in the course of his tenancy or thereafter?
I have, yes.
Okay. And did you sometime around July 24th, 2023 receive a demand letter from Mr. Hagan?
I received a fax number. I received a fax in my email from the corporate office, yes.
Okay. And Your Honor, I haven't marked exhibits, but I have.
We have stickers, so if there's anything
Okay.
you'd like me to take
I
a look
think,
at.
and I'm not sure if this has already been filed or not, but I think I would need
Let's
some
go ahead. We'll get
stickers.
you,
and
we got a lot.
we'll just
here,
make
so yeah,
sure.
take as many as
Okay.
you need,
And I have a copy as well for Mr. Hagan and for the court.
Please, thank you.
Thank you. I'll just mark this one and hand it to you real quick. Okay, and I'm handing the I'm normally the plaintiff, so I may trip this up. So I'm handing the defendant what's marked as Defendant's Exhibit 1. Ms. Workman, do you recognize this document?
Yes.
And what is it?
This is the demand letter was received via fax.
Okay, and does this appear to be a true and accurate copy of the demand letter that you received?
Yes.
Okay, Your Honor, we moved to to enter this exhibit. I'm wondering now if we should do Exhibit 2 since the stipulated agreement was 1?
Well, that was Court's Exhibit 1, so we're
Okay.
on Defense Exhibit.
Okay, perfect.
So before we do that, you're offering Defendant's Exhibit 1, Mr. Hagan. Have you had a chance to look at this one yet?
Yes.
And your position on whether this exhibit should be received by the court, meaning I can look at it and consider it in making a decision today.
Absolutely, it's accurate.
All right, then Defendant's Exhibit 1 is received.
Thank
And
you.
then go on.
And upon receiving this letter,
Mhm.
did you review the letter and understand what the request was?
Yes.
And what amount of money was Mr. Hagan offering or requesting?
That's $10,000.
Okay. And did you review this letter prior to the court proceedings for Mr. Hagan's eviction?
Yes.
Okay. And did you contemplate the amount that the defendant, Mr. Hagan was asking for when you were advising your counsel regarding the first appearance and possible settlement?
Did I contemplate giving $10,000 to Mr. Hagan?
No, did you contemplate that he was requesting money as part of his tenancy or a complaint regarding his tenancy? So you were aware
Yes,
at the first appearance and discussing with your counsel how much he was requesting?
Yes.
And did you intend to give him $10,000
No.
in exchange for his complaints?
No.
Okay. And so did you have conversations with your counsel about settling this case at the first appearance?
No. No, we were going to, we wanted to go through with the eviction, but we were having other extenuating circumstances with Mr. Hagan and needed to move forward with treatment of the building.
Okay. And so, but prior to the first appearance,
Mhm.
did you direct your counsel with a settlement offer with a certain amount of money?
Yes.
Okay.
In the 11 and a half hour
Okay.
they were here.
Okay. So, but you had a discussion and directed counsel a monetary amount to settle the disputes related to the tenancy?
Yes, I had to investigate what the minimal amount was for SROs for relocation fees.
Okay, so you came up with a dollar amount, and did you believe that this would resolve all of the issues with the tenancy?
Yes, absolutely.
Okay. And was this payment of $2,900 made to Mr. Hagan?
Yes, it was.
Okay. I have no further questions at this moment, but we'll reserve for redirect.
To Mr. Hagan, any questions of Ms. Workman?
Let's see. When you reference the treatment of the building due to circumstances, what is that including?
It includes the bed bug treatments and your refusal to allow us into your home that we have documented since 2021, and the need to get it treated per city code because we were in violation. And city code references by the city inspector, which your home specifically was not allowing us to treat.
And how long were you notified of bed bugs at Argyle Gardens in our building?
Several times, and we have every time that Mr. Hagan would not allow us to do it. And I can, if I could have time to print it up, I even have the 2 times in which I have up to $500 in charges each time that your home.
I'm not
denied
sure
entry.
that's not what I asked. I'm sorry.
Oh, but that's why we wanted to offer if a person is not happy, we choose to go by the Portland relocation fees and give cash for keys.
All I asked was just how long had you had bed bugs there?
So I think your objection would be non-responsive.
Yeah. So how many months would it be that you could say?
Well, I've only been employed with Quantum since June of 2023.
And you're not aware of anything before that, or?
I can only answer for how long I've been employed.
Okay. And when you were saying you were contemplating the relocation fees for the SRO,
Mhm.
Is there any reason that wouldn't show up in this settlement agreement or when you communicated with your attorneys?
Objection, Your Honor, speculation, and Ms. Workman did not draft the agreement.
You can repeat the question. I want to hear it again, make sure I get the.
Could you explain why when you referenced relocation fees, that was not communicated to your counsel or attorneys to be added into this stipulation?
Okay. Yeah, sustained.
Thank you.
Okay, ask another question, Mr. Hagan.
Can you explain why there's no, when you directed the attorney, O'Day, excuse me, to draft this, is there any reason or why didn't you include the language that would have referenced the $10,000 or the letter that I sent?
Objection, Your Honor. Ms. Workman did not draft this agreement, so she can't speak to the contents of what was in the agreement.
Sustained. Ask another question, Mr. Hagan.
Can we look at the testimony? I'm pretty sure it was stated that she directed the attorney O'Day to draft this stipulation.
I think it's clear this is, Ms. O'Day is her attorney. Certainly the attorney would have presumably been acting in the capacity, wouldn't have been off,
Correct.
going rogue and making agreements without that. So I think
That's what. So
I'm operating with the assumption that this is, anything that was written was done with the approval of the plaintiff or of the defendant. Sorry.
exactly, and Your Honor. So my question was not did you write the document, but was why when you
Maybe there's another way to
directed
ask the question that would get what you're looking for. So
well, I'm just asking when she directed the attorney.
I think you can ask, did you direct? I don't want to put words in your mouth.
Right. Okay. Because I was speaking to you. Did you direct the attorney O'Day to reference the $10,000 or anything about the letter that was sent to be added into this stipulation to make it clear for everyone?
I don't give any advice on how to write a legal document.
There's your answer.
What is your role in directing your attorneys then?
Objection, Your Honor. Asked and answered.
I'm going to sustain that objection. So if I ask another question, Mr. Hagan, or if you have any, I don't know.
Well, I'm just trying to see what role she played, and it just seems like on one hand she's saying she directed her to do this, and then I'm just trying to figure out why wasn't this included if it was directed. Regardless, I wasn't anyway. Yeah. I think that's it for me.
Okay. Ms. Adigade, any other
Sure,
questions?
just a couple questions on redirect. So Mr. Hagan mentioned reports of bed bugs. Was it your understanding that those were his complaints regarding the habitability?
Yes.
Okay, and do you recall any other habitability complaints or complaints that was received by Mr. Hagan related to the state of the unit? Or was it just related to bed bugs?
As far as my knowledge goes, it was only related to bed bugs.
Okay, and you also indicated that Mr. Hagan refused treatment of the bed bugs on multiple occasions?
Yes.
Okay, and so as part of the agreement to vacate, was it the intention that you be able to go remediate or treat for the bed bugs?
Yes.
Okay, so the habitability that he speaks of in the demand letter, from your perspective, was directly related, in addition to other things, of him vacating the unit, correct?
Yes.
And was it, why was it important to be able to eradicate or treat these bed bugs?
Because we had city violations.
Okay, and so treating them would avoid the city violations or cure those?
Mhm.
Okay, thank you. No further questions, thank you.
All right. Okay. So
Would I be
Mr.
able to?
There's no
Cross again?
redirect.
Okay.
You already had cross-examination, so
Okay.
at this point, and you don't have any other witnesses, right?
No, Your Honor.
Okay. So then, Mr. Hagan, over to you, and I guess as sort of your counsel and your own witness, I'll go ahead and swear you in first. Please raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the testimony you're going to provide in this matter today will be the truth, the whole truth, and nothing but the truth?
I do.
All right. If you could please state your full name, spell your last name, and then I'll just turn the floor over to you.
Daniel Michael Hagan, Hagan.
Okay. And I think, frankly, you've already made arguments, so if you want to make additional arguments, I think I kind of understand your position here. I want to give you every opportunity to provide any other information. And keeping in mind, again, we're not talking about the ultimate merits of your case, but just about
Absolutely.
whether this $2,900 payment wrapped up everything, and that means that this case should just be dismissed on that basis.
Correct. So, Your Honor, I'm not going to address the service of this, which it seems to be fine from this end, but the stipulation is only $2,900. I don't think anyone would settle for a clear-cut case of $10,000 for $2,900, or other civil cases that could come in the future. Considering the conditions and the environment, $2,900 for just moving just would not be, I would never have accepted that. And I'm just a little flabbergasted that this is being interpreted as the end-all be-all of anything that I could bring against Quantum, when it's only, and they had the opportunity to add their own language that would have made this the end-all be-all. So I'm saying, can we dismiss the motion? Considering that the defense has not lifted a finger to do anything in this case. In fact, the judge should have rejected the motion for counsel because it was submitted by their attorneys before they were allowed to be their attorneys.
That's water under the bridge at this point.
I understand, I know. So that's my case. It's clear cut. There's nothing in the language in here at all that would give any normal layperson the idea that they could never bring anything against Quantum Residential ever again.
All right. Ms. Adigbade, any questions?
Just a couple of questions. Mr. Hagan, do you dispute that this letter was sent to Quantum?
I do not dispute that this was sent to Quantum.
Okay, and you list in here ORS 9385, retaliatory conduct by landlord. Did you file any answer or any documentation in the landlord-tenant matter related to retaliation?
No, because I settled, so there was no need to deal with that.
Okay, So, and then you also list habitability issues. Did you bring any counterclaims, any defenses to the landlord-tenant matter, file any documentation related to those issues?
No, because that's a landlord-tenant issue.
And when did you file the small claims action?
July 28th.
Okay, and after August 15th, 2023, did you bring any other action regarding this matter?
Yeah, I think I filed the default judgment. Offhand, I don't have the chronology here. If you want to give me a moment, I will look for it. But I think the only thing was filing for default judgment. August 21st, excuse me.
So you said...
motion for default judgment was August 21st.
Okay, so you filed for default judgment. Do you have with you the certificate of service that you filed in the small claims case?
I do.
Okay, and Your Honor, this was filed in the small claims case. I'm happy to provide a copy to you, but I believe that it is in the filing.
Let me just take a look here. And what approximate date would we be looking at here?
August 21st, Your Honor, 2023.
Well, the service was on. Well, are you talking about for the default judgment or for the?
For the small claims case.
Okay, that was signed for on the 2nd of August.
Well, I'm looking at the motion for default. We're talking about the motion for default.
No,
judgment?
Your Honor, no, we are looking, I'm looking at the certificate of service that was filed August 21st.
Okay, and
It doesn't indicate, Your Honor, on here what this service of.
yeah, the reason I was asking is that in our court's file, it follows immediately on the tail of the
default.
defendant's motion for default judgment.
Well, I will note for the court that on the portion that requires that you indicate what was served, there is nothing indicated there. And do you need a copy of this that I was going to ask you questions about?
Let me see here. I should have that.
Well, I'll just hand you a copy so that we can move along. And Your Honor,
And just to be clear, I know we were here on the motion. My understanding was the original motion that brought us all here today was your position was that this agreement sort of stopped any further movement on the case. I didn't see anything about the service being anything that we were going to be talking about today.
Your Honor, my client never received a proper copy of the summons and complaint. We never received the default, and so.
Well, I'm not saying that
Right.
never didn't happen.
No,
but
I just-
typically like if there's something that brought us here, like there'd be something telling me like here's all the different things that we want to have a company.
Yes, and Your Honor, we can address it if the court is not convinced with the argument. I wanted to.
Let me just kind of tell you where I am
Sure,
right now. Because
sure.
with the estoppel issue, I'm looking at this agreement here, and my understanding it was written by an attorney acting as a representative of Quantum Residential. The reference is to a one-time payment of $2,900 on the condition that the defendant fully comply with the terms herein. Doesn't reference anything else, so kind of I keep coming back to that sort of elementary contract thing. If there's some ambiguity there, we resolve that. Not in favor of the person that wrote the agreement, and so when I have a reference to $2,900, I have Mr. Hagen's demand letter, this defendant's exhibit 101. It references a lot of different dollar amounts. None of those are $2,900. Certainly if I had at least something that kind of pointed to that and said, well, he asked for $2,900 and here's $2,900 over here, and we might be having a different conversation, but I can't find based on this agreement that even though what you've described is a perfectly reasonable conclusion about what the intent of the Quantum Residential would have been. It's just, it's not reflected in the agreement. And so I can't say that it was so obvious to everyone involved that it was intended to preclude things. I even look at the agreement itself, and because this is one that's typically a landlord-tenant agreement, typically we're talking about landlords wanting tenants out of their property. They even bother to write in here that, you know, whatever's in this agreement has nothing, you know, no impact on the plaintiff, normally the plaintiff landlord's position or ability to move forward in, you know, trying to recoup damages or, you know, pursuing any other remedies they may have. So I can't just say that, like, everybody knows this agreement always means it takes care of everything either. So I have to say I can't go with your argument here that there's an estoppel issue. My understanding is, based on the information I had, was that that's what we were all here today to talk about. I don't see anything here that there was any intent to bring up the service issue. So my position at this point is, given that it's not clear to me that nothing that I see here indicates that the court was even aware of it, so I can't believe that Mr. Hagan would have had a reasonable opportunity to show up today prepared to talk about that issue. I'm not prepared to make a ruling on that. Certainly you're free to re-raise that
Absolutely.
at any future hearing, and I'm making no findings whatsoever about the underlying merits of this case. But I will say that I will deny the plaintiff's or the defendant's motion to find that plaintiff is stopped from pursuing this. So that will be denied. And do we have a future date on this already, or what's our?
Not yet. It would need to be some mediation.
Oh, so next up, set for mediation. Do we do that, or is that just that's kind of a normal court thing? Just let everybody know.
Okay, and Your Honor, just for clarification, I'm not sure if Judge Johnston intended to allow counsel on this matter to its conclusion, or simply for this hearing.
Well, I think to the extent, that ruling's already been made. I think from my perspective, if any judge had intended to limit the representation to a single hearing, that would have been the thing to write down there.
That's kind of what I was thinking, but I just wanted to clarify that.
So to the extent that any order today needs to reflect that, I guess we can put that in any order I think to me it's obvious that.
Okay, and Your Honor, just one other thing, just that I'm hoping to clarify. So, I'm not gonna get into the service issue, but the claim that was served to the wrong address, the court recently used that incorrect address to send documents to my client. In OECI, you'll see that there was returned mail. So I just wanna make sure that any further communications be sent to my office.
Yeah.
Or in the alternative to the correct address for Quantum.
Well, you are the representative on this, so I'm fine as long as Ms. Workman's okay with that, to have that sent to you, and then.
Perfect. I just wanted to make sure that we don't have that
Sure.
error going forward.
Understood.
Okay, so we will then wait to receive a notice of mediation with a date.
Yeah.
And Your Honor, when would I be able to file a motion for counsel for myself?
I suppose you could file it any time. I don't know that.
How formal does that have to be?
I think the customer service folks, the desk out there, can probably give you a little more guidance. I can't really give you legal advice.
I understand.
About
I understand.
how to move forward on this, and can't give you any prediction on whether that request would be granted. But I would check in with those folks. They've got a million forms out there. That may even be one of the forms they have. So,
Okay, perfect.
and if not, you can probably just write it down on a piece of paper. I think, frankly, I'm not prepared to rule on that today because we were here.
No, I
We
understand,
were here
yeah.
for one discussion and one only, so that's kind of what I was looking into. But you're absolutely free to file anything, and then we'll have to sort that out some other day. I'm sure the court has your address, so that shouldn't be an issue there.
Yes, absolutely, and it's in the landlord-tenant case as well.
Okay.
So, and one more thing, Your Honor, I just want to mention for the record that the defendants didn't request this hearing. Judge Johnston must have noticed it and
Okay.
put it on the docket. So, just want to make that clear.
Understood. So, yeah, it wasn't clear to me from the I mean, normally there's in the courts system here, it's fairly obvious, why we're here, and this one was a little bit ambiguous.
Yes,
but
I think that, and we, again, since we did not receive service of it, we didn't know that the case was here until we received that order, so.
And yeah, just for everyone's edification, if you didn't, I'm assuming actually you all got this order back on September 29th, that they just said that this matter was to be set on the motion docket to determine if the agreement entered into on 23 LT 12731 encompasses the resolution of claims asserted in this case.
Yes, so I think it was Judge Johnston who wanted this sorted,
Got it. Okay.
Not the defendant.
Presumably, yeah. I mean, putting two and two together, obviously, it sounds like it's an issue that you probably would have raised rather than Mr. Hagan, and then that's how it got here. So now I clear a picture. So thank you for that.
Absolutely.
The updated quantum address.
I do. So the correct quantum address is 601 East 16th Street in Vancouver. And it is the correct address on the notice of small claim that was filed. It's just different in the mailing section. And that is the correct address, correct? Okay.
Zip code?
98663.
Oh, perfect. Yeah, that way it's no future, well, substantially reduced likelihood of confusion.
I like the hedging.
Yeah, it's always something you start thinking we've got it all figured out.
Right, right.
It's great if you want to add things to it. Unless you're pretty
While you were doing that, I was signing one of the other orders this morning. So let me just finish that one real quick.
And then the defendant for challenge to garnishment online, he got the wrong hearing notice.
Oh. Well, the good thing I didn't sign that. So let's just back right out of that one real quick. And then we'll get you all on your way, and then we'll turn our attention to something.
Thank you, Your Honor.
So I understand we have Mr. Goodwin joining us by WebEx. Is that right, sir?
Yes, I did not want to interrupt. Thank you, Your Honor.
Quite all right. You're in the right place now, so sit tight. I'm sorting out one other matter, and then we'll come back to you in one moment.
Thank you, sir.
You're welcome.